Hello class, and welcome to your Chapter 7 lecture, where we're going to be discussing community supervision, modification, and revocation. So let's dive in. Our learning objectives for this lesson are that by the end, you should be able to identify how probation and parole conditions are modified and under what circumstances they are modified, as well as list the progressive sanction options that a probation and parole officer have available to them before they decide to file a revocation report with the courts or the parole board. Analyze the legal rights and options that probationers have during the revocation process. And finally, to discuss the offender's demographic and situational factors that will increase the chances of succeeding on probation and parole. So, when making the decision to modify or revoke probation, what is going to guide the officer's discretion? One, you have the severity of the offender's behavior. How severe is it? How serious is the behavior that the offender is engaging in that we need to consider revoking or modifying their probation or parole? How intense is the supervision that they're currently under? What are the agency's policies and laws on revocation? And what about the principles of rehabilitation? What have we done so far to rehabilitate that offender? So we can make the recommendation as a community supervision officer to terminate early the person's probation for good behavior. The authority, however, lies with the parole board or the judge. So the probation officer is going to make the recommendation to the court or to the parole board that the offender should be terminated for good behavior. Research has shown that terminating for good behavior someone's probation early does not increase their risk for recidivating. So when we look at revoking probation, revocation is simply the process of hearings that will result when a probationer is not compliant with the current level of probation supervision that they're under. Typically, graduated sanctions must be tried first before the offender can be sent back to prison. So a modification or withdrawal of probation with a sentence can be community facility, jail, or prison, but typically you need to show that you have tried other things first to help that offender get in line with and be compliant with their probation before you can send them back to prison or jail. So what are the different types of violations that we can have? There are two main categories. You have law violations and technical violations. Your law violations are simply when an offender commits a new misdemeanor or felony offense while they're under supervision for a different offense. These are your true indicators of true recidivism. Is the offender actually engaging in more crime? Then we have technical violations. So these are multiple violations that will breach one or more non-criminal conditions of probation. So officers who have higher caseloads are actually more likely to recommend revocation earlier for an offender because they don't have the time to devote to rehabilitating and working with that offender. Some of the common types of violations we see are continued drug use, failure to complete drug treatment, and failing to report to the probation officer. So looking at recidivism rates depend on a few different factors here. First, how are we defining recidivism? Are we defining it by new arrests? Are we defining it by the number of technical violations? Are we defining it by even just their contacts with law enforcement? What is the duration of time that the subjects were being tracked? Were they only tracked for 1 year? Do we track them for 10 years? What is the size of our sample that we're studying? When looking at recidivism rates, you want to take all of these into account, and you also want to take into account the decision-making style and behaviors of the probation department and officers, as well as parole, and the judge. So we know that some judges are more lenient than others. You can have pendulum swings in the courts where you have one judge that's very strict and seems to agree with whatever the probation department recommends at that hearing. And then you may have other judges that will challenge the probation department and say, we're not going to go ahead and revoke this probation so soon. You're going to need to go back and try more options first. We're using our least restrictive options here. So you have to take into account all of these different factors. When you're looking at recidivism rates that are being put out there, you want to consider all of these different things to be able to understand what type of recidivism are we truly looking at here. So absconding from supervision is one of those issues that we have to deal with as a community supervision officer. And research shows that roughly 12% of parolees and 18% of probationers will abscond from supervision. The violations that they're running from, because typically they abscond because they violated their probation or parole, typically whatever that initial violation was is less serious than what they're going to be in for absconding. In these cases, warrants are typically issued. This is considered a technical violation. However, sometimes in certain states, it can be listed as a new criminal offense, especially once that warrant is issued. This is when an individual either escapes or flees the jurisdiction without having prior permission. So typically when an offender is on community supervision, they're not supposed to leave the county that they live in. But we know that this is unrealistic at times. Say they work right outside of the county. Well, they should have prior permission for that. But especially when an offender is requesting to go out of state because of that interstate compact, we have forms that need to be filled out. We need to make sure we're letting that state know, while we're not sending them the case to supervise, we're letting that state know that, hey, this offender is coming to your state for this time period and they're going to return to us. If that offender does not return when they're supposed to, they can be considered an absconder and a warrant could be issued. Unfortunately, most states will take a passive approach to locating and apprehending these absconders because there's such a large number of them and such a limited amount of resources to go out there and find these offenders. So in Cleveland, Ohio, they tried this fugitive safe surrender where they would set up in churches and you would have law enforcement, they would basically set it up as a courthouse. So you would have a judge there. The fugitives could actually come and turn themselves in and they would be seen as the courts would be a little more lenient on them because they were turning themselves in. So it gave them the opportunity to have a quicker hearing. So in this 4-day pilot program, you'll see I've highlighted here, over 800 fugitives turned themselves in. The contrast to this is that when the Fugitive Task Force would conduct a sweep over a 3-day period, specifically taking all the warrants and going out to find these individuals, they only would make 65 arrests. So you see here, you have a much higher rate of return of offenders turning themselves in. So this was an opportunity for them to turn themselves in, you'll see, in an atmosphere that's more comfortable than walking into maybe a courthouse or walking into the probation department and not knowing what's in store. And because a judge was there, it gave them the opportunity to have their cases adjudicated immediately, right then and there. We know the court process can take a very long time in some cases. So this gave the offender the opportunity to know that, let me just go and get this taken care of and get it over with. It was also a safer option than having law enforcement go out and conduct these sweeps, where you have some offenders who are going to be scared, frightened, they're going to start running. They may even, combat law enforcement. They may even start shooting at law enforcement, depending on what their current situation is. So it's just a safer option than law enforcement going out and conducting these sweeps. So looking at in-house progressive sanction options. So say you have an offender that has started to not comply with their violations. So this is when an offender shows initial signs of resistance or when you see the first technical violations starting. The probation officer is typically going to gain supervisory approval, or they'll use pre-established written guidelines that the department has to address the offender's first initial violations. This can include things such as short jail stays, having an oral or written reprimand. the officer may use motivational interviewing or even give the offender new directives to comply with. These need to be swift and certain, but it also helps to avoid revocation and long-term incarceration. So by having swift and certain sanctions that an officer can use at their disposal to address these violating behaviors, it helps avoid that officer having to put through a revocation and then the offender facing a long-term incarceration. But it's also important to make sure that we're not just giving the offender sanctions, but that we also have positive rewards for when the offender is doing well. So I urge you to take a look at the matrix on page 176 of your text, and it will show you some different options for rewards and sanctions that are typically available to probation officers to deal with offenders. So some of these supervisory strategies to reduce the occurrence of technical violations will one include first a sound assessment of that offender, and then you need to have a sound case treatment plan, which you guys completed in a previous module. So by having these sound assessments, so your risk assessments, having different mental health assessments or drug and alcohol assessments, you use all of these and you put them together in your case treatment plan to provide a roadmap for the offender. And the more these are individualized and the more sound they are, the better the chance of your offender not having, the better chance of your offender not violating and you not having to put through a revocation. So what happens in a revocation process? Well, this will apply when any in-house strategies have been exhausted and the offender is still not following through with them. Typically, the revocation procedure in a department is governed by a combination of the constitutional rules, state law, as well as agency policy. A lot of agencies will have written out, again, a roadmap for the officer to understand once you've tried all of these different in-house strategies, your only option left now is to file a revocation. So it begins with a violation report that the supervision officer is going to write up. This is why data is so important and making sure that you're writing down and documenting every violation the offender has had, because this report is going to include a chronological of all of those violations. But you'll also want to include, as a supervision officer, what in-house sanctions you have tried and how they've been unsuccessful, so that you can almost prove your case to the courts of why you're filing the revocation. Offenders in this case can either be arrested immediately by the community supervision officer, or that officer can issue a warrant for their arrest or a citation for them to appear for a revocation hearing. So again, you have three options there. You can go out and arrest your offender. You can issue or ask that a warrant be issued for them for their arrest. Typically, you're going to do that if you think the offender is maybe going to be violent, if you can't find them, if you don't know where they are, and or the citation option will just send a citation to their home saying, hey, you need to come now and appear for a revocation hearing because you're not being compliant. So, revocation is a two-stage process. First, you will have a preliminary hearing, then you'll have your final revocation hearing. During the preliminary hearing, this is where it's an inquiry conducted to determine whether there is probable cause that an offender has committed a probation or parole violation. And this is going to be determined whether there's a preponderance of the evidence that exists to believe that a violation occurred. The final revocation hearing is a full due process hearing. So this must be conducted before the probation or parole can be revoked. Typically, imprisonment is not going to be mandated at the state and local level for a revocation. The offender can have their probation modified. They can have additional conditions put in place. These are all additional options rather than going to imprisonment for a revocation. And the offenders can actually waive that preliminary hearing if they want to quicken their proceedings and just go to the final revocation hearing. Revocation in the federal system is a bit different though. So an offender can actually choose to have an expedited revocation, where in an expedited hearing, the offender must admit their wrongdoings. They will waive their right to a revocation hearing, but that means they then do not have the right to appeal that decision later on. So it helps them to quicken the process for those that just want to get it over with, but with the understanding that they cannot appeal that decision then. Revocation in the federal system typically mandates imprisonment. You're not going to simply have your probation modified as you would at the state or local level. A mandatory revocation is necessary for certain violations. Some of these violations include having a new crime of violence or sexual contact against a child under the age of 16, possessing a firearm or a controlled substance, having a positive drug screen, or even refusing to comply with a drug screen. So refusing to submit to a drug screen is oftentimes seen and written down as a violation of probation because you're assuming that it's going to be positive. Because why else would an offender not want to comply with the drug screen and show that they haven't been using any substances? We do have some legal issues that we need to discuss during these revocation hearings, and we're going to go into more detail in the next few slides. So in the case of Hampton v. State, it basically said that the administrative hearing is very similar to a civil proceeding. So due process rights must be afforded to these parolees and probationers during revocation hearings. And there's two main cases that made this determination: Morrissey v. Brewer and Gagnon v. Scarpelli. So what rights does an offender qualify for during a revocation hearing? Well, there are 6. First, they have the right to receive written notice of the violations that are alleged against them. They also must be disclosed the evidence that is presented against them or going to be presented. They have the opportunity to speak at the hearing. They have the right to confront and cross-examine any witnesses. They have the right to judgment and the right to provide a written or to be provided a written statement of reasons for the revocation. And juveniles will be extended additional due process rights during these hearings. So what rights are limited to the offenders? So in People v. Price, the court said that offenders are not constitutionally entitled to a jury nor a speedy trial in revocation hearings. Perry v. State went on to say that they're also not entitled to the Fifth Amendment privilege against self-incrimination because they must admit to their wrongdoings. And then in Gagnon, not that they have to admit to them, but they can be found guilty of them. And then in Gagnon v. Scarpelli, that they're not entitled to court-appointed representation during revocation proceedings unless they are physically incapable of speaking for themselves. So what level of proof is required and what evidence is required during one of these hearings? Well, the standard of proof for a revocation is a preponderance of the evidence. So it's a lower threshold, just a preponderance of the evidence. They say that's about more than 50% sure. The probationer also has the burden of presenting evidence to overcome prima facie proof, which is just at face value, that the revocation occurred for a conditional violation. Also, the arrest, just because the offender is arrested, that's not enough to revoke their probation. However, having an indictment by a grand jury or a conviction for a new offense is enough. And then parole revocation is permissible even if those charges are later dropped. So hearsay can actually also be admissible in a revocation hearing in 3 instances. So if the information is corroborated by the parolee's own statements or by other testimony that's given at the hearing. If the information fits into one of the exceptions to the hearsay rule, or if there's other substantial indication that the information being provided is in fact reliable. In those cases, hearsay can be admissible in a revocation hearing. So other situations that we can have for revocation are an inability to pay. However, for an offender to have their probation revoked due to not paying, it must be willful and intentional. For example, an indigent probationer cannot have their probation revoked as long as they weren't the failure, as long as they weren't the cause of the failure for them to pay. So, say an offender has a job and just doesn't have enough money to make those payments because they're trying to pay their rent, their car bill, maybe they owe child support. So it's not willful and it's not intentional, they simply don't have the funds. However, say a probationer does not have a job, is not trying to find a job, and therefore is unable to pay, then their probation could be revoked. But in these cases where a probationer is claiming that they're indigent, they have the burden of proof of proving that they are indigent and that they cannot pay. The time an offender spends on probation or parole is also typically not credited towards their sentence if they end up having their probation revoked. So say they serve 2 years on probation and they end up having their probation revoked, those 2 years do not count towards their sentence. However, the federal courts and a Florida statute does now allow for either some, none, or all of the time that probationer has served on community supervision to be credited toward an institutional sentence. So again, revocation is permitted at times for unwillful failure to comply with conditions if public safety is threatened by not revoking their probation. So this is another special situation. So an example here is that say a sex offender is not able to complete treatment because there's no availability of services. So it's not willful on that offender's behalf that they're not complying with their treatment. They simply can't get into a program. However, public safety is threatened by that offender not having treatment. So in that case, to make sure that we're keeping the public safe, we may end up revoking their probation until we can get them the proper treatment and services in place. All right, so what do we do when community supervision ends? So let's look at the recidivism and offender characteristics for offenders. So offenders who possess skills, who are high school graduates, who have completed treatment, have conventional ties, so they have family, maybe they attend religious services, who have positive social supports, are less likely to recidivate. Whereas young, unmarried, those who have previous convictions and who lack emotional maturity are going to have higher failure rates and are going to recidivate more frequently. After 24 months, though, after 2 years, it's shown that recidivism rates will typically level off for the next 2 to 5 years. So after an offender, the first 2 years there is when we're going to see recidivism rates creep up, and then the next 2 to 5 years after that, they typically level off. Probationers are going to actually recidivate less than parolees. So remember, probation is in lieu of jail or prison, whereas parole is after the offender has served a term in an institutional setting. So probationers have less recidivism than parolees do. This is important to know that the first 3 months that an offender is on supervision is the most vulnerable time for them to receive a revocation. So when looking at recidivism rates of prisoners who have been released over a 3-year period, at the state level, we see that roughly 68% of offenders will recidivate. At the federal level, this is down to 35%, looking at 3 years post-release. And they found that those who are male, African American, and between the ages of 25 and 39 are going to have higher recidivism rates than their counterparts. So why have we had revocation rates increasing in recent years? There's 5 reasons for this. First, there's a lower threshold for tolerated violations. That simply means that we're not allowing offenders to violate as many times before we're bringing them back for a revocation. There's an increased number of offenders that every community supervision officer is supervising, which means these officers are having less contact with those offenders. So they're not able to be as much of a part of that rehabilitation process as we would like to be. There's also an increased number of parole conditions, so there's more ways that the offender can violate that. We also have advanced drug testing now, so we can detect more drug use. We have rapid tests that you can take right out to the offender's home, test them right there in their home, or have them come into the office and test it right away. We don't need to collect a sample, send it out to the lab, wait for it to come back. So we have advanced drug testing. We can also detect more drugs on those instant tests than in past years. There's also an increased use of data sharing and technology that can better track recidivism. So by having these better data sharing systems and better technology, we can track recidivism rates better and more. So we just see these revocations more than we would have when we didn't have such great data sharing between different counties, between different states, and when we didn't have the technology to run all of these research studies, to run all of this information and give us all the data back out. So what are some alternatives that we have rather than incarcerating an individual for technical violations? So when we're looking at technical violations, they suggest that we set the maximum term of supervision to no more than 2 years. When you're putting an offender on supervision for so long of a period of time, it's inevitable that they're going to eventually violate in one of the technical fashions. I know we've had juveniles on electronic monitoring for long periods of time, and they might do well in the beginning, but after a while, they get frustrated, as any individual would. Same thing when an offender is on just regular supervision for too long of a period. They start getting frustrated. They start violating because they're tired of checking in with you. They're tired of having to comply with all of these different rules and conditions, and it just gives them more opportunities to violate. We can also use residential halfway houses. They're cheaper than incarceration, and we'll go into these residential halfway houses in a later chapter in much more detail. We can also lower the number of standard conditions that an offender has to abide by. So there are certain conditions that every offender gets that we talked about. You have standard and special conditions. But by lowering the number of standard conditions, one, we can have this be more individualized. Just because they're standard and they're supposed to be for every offender, does that offender really need that stipulation? For example, curfew. Say the offender has no issue with curfew at all. They're in on time, never been an issue. Why do we even put that down then as a condition? It just is one more rule in the back of their head that they're thinking, I need to make sure I'm complying with this. I need to make sure I'm in by 8. Whereas if it wasn't an issue before, let's not make it an issue. That's just one example. So, in sum, offenders who are doing well on supervision should be rewarded. So we want to make sure that we're not simply sanctioning offenders for violations, but that we are also rewarding them when they're doing things well. In-house progressive sanctions should be used in a swift and certain manner to respond to technical violations prior to putting forth a revocation recommendation. Community supervision officers are going to make that initial recommendation to revoke. However, know that the judge and the parole board are ultimately deciding whether that probation or parole should be revoked. So I should have clarified this. The judge is going to make the decision typically for probationers, whereas the parole board is typically going to make the decision for parolees of whether the probation or parole should be revoked. Time served on probation is typically not credited if revocation ends up resulting in a prison sentence. However, as I said previously, federal courts and now a Florida statute does allow for some time served on probation to be credited. Probationers and parolees must also be afforded due process rights in a revocation hearing. However, they do not have a constitutional right to an attorney at that revocation hearing. However, they can be afforded one if it's deemed that they're incompetent and they cannot represent themselves. And finally, there is an increase in revocation rates due to numerous factors that we covered on the previous slide. So that was your Chapter 7 lecture looking at modification and revocation of probation and parole.